What happens when a green card holder sponsors their spouse and then that green card holder becomes a U.S. citizen? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. The situation we're talking about here are situations where a lawful permanent resident has sponsored their spouse for a green card. That spouse may be in the United States, that spouse might be overseas. Now, we know based on immigration law that U.S. citizens can sponsor their spouse and there's no backlog, no delay, no limit on the number of green cards available for their spouses. So all that means is you have to wait for the process to run its course, for the green card application for the spouse to be processed, and then the spouse of the U.S. citizen can come to the United States. That's not the situation when the sponsor is not a U.S. citizen, but rather a green card holder themselves. So in those situations, Congress has put a cap on the number of visas that are available each year. And so that has created a backlog. Basically, you file the paperwork and the applications get processed, but you have to wait for your place in line. You have to wait for what's called your priority date to become current. And so what happens is the green card holder will sponsor their spouse by filing an I-130 petition for an alien relative. And if that spouse is overseas, then eventually that case will get processed and scheduled for an interview about 2 years later. If the spouse is in the United States, again, you can only file the I-130. You can't file for adjustment because your priority date is not current. So the way that that process works is an I-130 petition for alien relative is filed by the green card holder for their spouse. Now, one thing to keep in mind is that that spouse is going to have to be in status throughout the process. If the spouse falls out of status or lets their visa expire or they violate the terms of their visa, then they're not going to be able to adjust status themselves until their green card sponsor spouse becomes a U.S. citizen. This sounds a little bit confusing, but let's just make an example. So let's say you have a guy named Abdul. Abdul has a green card, and he wants to sponsor his wife, Farida, for a green card. And Farida's in the United States on an F1 visa. Abdul files the I-130 petition. It gets receipted, and it starts getting processed. Now, the USCIS knows that the visa is not going to become current for about 2 years, so these cases generally take a little bit longer, but it doesn't really matter once you have that priority date because that's your line ticket. And so if Abdul files that green card application or files the I-130 petition and it gets receipted, then Farida is going to have her priority date. And if Abdul becomes a U.S. citizen while Farida's case is still pending, then what you do is you can notify USCIS that Abdul has become a U.S. citizen. You'd send in a copy of his certificate of naturalization, and you'd alert USCIS to the fact that he has become a citizen. And then his priority date becomes irrelevant. It's then the spouse of a U.S. citizen, and the case should process along normal processing times. Now, it is a little bit tricky to get USCIS to pay attention because when they open up the case, they mark it down as the spouse of a green card holder, and getting them to wake up and pay attention and notice that Abdul is now a U.S. citizen changes things a little bit. Now, what happens if the citizenship happens after the I-130 has been approved? Now, that's an even bigger bit of a problem. So in that situation, the I-130, if it's been approved, it will probably have been sent to the National Visa Center. USCIS treats it as if the foreign national spouse, the person waiting for the green card based on marriage to a green card holder, is overseas, and so they don't necessarily know that the spouse is in the United States and they don't process it that way. So that's a little bit trickier. You have to notify the National Visa Center and USCIS that Abdul has become a U.S. citizen, and then you have to get them to process for adjustment here in the United States. Now, the one thing is we've done about 5 of these this last year, and USCIS has been pretty good about then recategorizing them as the spouses of a U.S. citizen and getting the cases on track. So it's just a matter of logistics. You file the I-45 at that point. Once Abdul's become a U.S. citizen, you notify the National Visa Center that Farida is in the United States and that she's going to adjust her status, and then things actually happen pretty quickly after that. So probably not a maneuver that you can do on your own. You're probably going to need some legal help. So if you have questions about this, give us a call at 314-961-8200. You can email us at info@hackinglawpractice.com. Please be sure to find us in our Facebook group, which is called Immigrant Home. And if you like this video, be sure to subscribe to our YouTube channel so that you get updated whenever we make a new video. And be sure to share this video with all your friends and neighbors. Thanks a lot. Have a great day.